It's a medical malpractice trial, and during a break in testimony, the judge calls over the plaintiff's attorney up to the bench. And he tells the plaintiff's attorney, the attorney who represents the injured victim, listen, you've got a problem with your proof. If I were you, I'd try and settle this case because I'm going to be dismissing this case when you finish up this witness's testimony. Can the judge do that? Want to know the answer? Come join me for a moment as I share with you some great information. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney, and the answer is yes, the judge can do that. The judge can tell him, listen, you don't have the proof necessary to go forward. You haven't been able to show that you are more likely right than wrong, that what you are claiming is true. There's nothing that you've put on in terms of testimony to show that a doctor violated the basic standards of medical care, that improper care was a cause of your client's injuries, or that the injuries are significant or permanent. And if all three of those things are not present and confirmed by a medical expert, then guess what? The judge will have no choice but to dismiss the injured patient's claim before it ever goes to a jury. So now if a judge calls up the attorney and says, listen, I'm going to be dismissing your case. So if I were you, I'd try and go ahead and settle this case immediately, get whatever you can, because otherwise the case is gone. Can the judge do that? The answer is yes, he can. From the attorney's standpoint, this information is crucial. Why? Because he knows that when he finishes questioning this witness, the judge is going to dismiss the case and his client's going to get nothing. So now it would be in his client's best interest to go ahead and try and negotiate, assuming, of course, that they have a willingness or a desire to try and negotiate. The defense attorney may already know in his heart, based upon what he's seen and heard, that there's no way that he can go forward with his case and that the judge has to dismiss this case. And in that instance, he may take a hardline position and say, hey, screw you. Let the judge go ahead and dismiss this case because I'm going to ask the judge to dismiss it after this witness testifies. And if I know in my heart that this judge is likely going to do that, I'm not going to negotiate with you. Why should I? I have an obligation to my client, the doctor, to go ahead and protect him. And if that means that you get nothing or your client gets nothing, so be it. So the attorney is going to be in a very precarious situation. But in all likelihood, he's going to take the judge's advice and try and begin negotiations before he gets back and starts questioning his witness again. So why do I share this quick information with you? I share it with you just to give you an insight and an understanding into what can happen in a medical malpractice case here in New York. You know, I understand you're watching this video because you have questions or concerns about your own matter. Well, again, if your matter did happen here in New York and you're thinking about bringing a lawsuit but have not done so yet because you still have questions that are unanswered, what I invite you to do is pick up the phone and call me. I can answer your questions. This is something I do every single day and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a wonderful day.